Paris and Philip have used this expression, showcasing Alastair. I'm reminded of when I took my daughters to Paris a year or so ago, and we took them to the Louvre, and we walked them all the way around the Louvre, and we finally said, and that is the Mona Lisa, one of the world's most famous paintings. And my older daughter went, yeah, can we get an ice cream now? So, by the way, did you hear that Farish said, in the interest of getting on to Alastair and then to the interesting part? I just want to begin by just saying it's fabulous to be here. It's really, really good to be back at the KLRCA, and I'm delighted to have this opportunity to be here. I was here in February for a few days as a sole arbitrator, but then I had to learn about the Malaysian and the international standards for measuring palm oil mill effluent. This is significantly more interesting than those 3 days, let me tell you. One of the problems with being the last speaker is, of course, that everything useful has already been said by the time you get to stand at the podium. And the reason there was a bit of a to and fro at the start of this session as to who was going to go first was that Faris had Sundra's marvellous slides, which contained a lot of excellent information, except, may I say, your comment about not wanting to encourage people to open their wallets to international law firms. Not so sure about that one. So I was trying to think about how I was going to pull this together ahead of a panel discussion. I'm also conscious that I'm following in the footsteps of a lot of people who've got titles like doctor and professor and fellow and things, whereas I'm just plain me. What I thought I'd do is not try and compete at that sort of academic level, which has been so comprehensively and so well covered already. I'm just going to try and bring it down to earth a little bit and just go back and think about how this issue of sanctions is actually hitting international arbitration in reality, which is, after all, what I think the theme of this conference was all about. And then we can build on that through the panel discussion. Let me start here. In practice, how important is this topic in practice? Let me tell you how often I've dealt with this subject in practice. Never. And that may be partly because I'm practicing in Singapore and Southeast Asia, and I'm sure that people in Stockholm and in other countries, Ben was talking about his practice in Korea, others clearly do deal with this, but I just wonder how many cases actually are raising this on a day-to-day basis at the moment. That's not to belittle the topic. It's a fascinating topic, and it's a worthwhile and important topic. But I don't think we should foster this idea that it's overwhelming international arbitration and that it's going to, in some way, kill our business. It is an important issue, but I don't yet have a feeling that it's a massive issue in practice. But nevertheless, it does impact in practice, and we've heard a number of ways through the course of today that it does that. And just to recap on some of them, maybe we can begin with arbitrability, this question whether sanctions just kill the whole case stone dead right from the start. I absolutely agree with the comments that we heard earlier that sanctions should not render a subject inarbitrable, if that is a word. For all the reasons that we heard, of course tribunals should be able to deal with sanctions issues just as they deal with competition issues and securities laws and all of the other topics that were discussed. And we nevertheless have to be aware that there are some courts that don't share that view in certain parts of the world. There is an issue there about whether sanctions will affect the basic arbitrability of the dispute that's coming in front of the tribunal. There are, as we've heard several times, issues for institutions. Will an institution even start a case? Fascinating example about the ICC receiving cases involving Iran. Fascinating and alarming that even the ICC, after a year, hasn't found an answer to that. The issues that we've heard around the movement of funds into an institution from a sanctioned entity or from a sanctioned state, and back again, because quite frequently at the end of the case there's a surplus of funds that has to be returned to the parties, and that may raise different sanction-related issues. Issues around whether the institution can even deal with a particular entity if that entity or the people who own it or control it are themselves sanctioned individuals. Those can raise questions for institutions, and it's not my job here to try and work through those issues. It's my job, I think, simply to identify all these different ways that the sanctions passed by the UN Security Council or by individual governments actually impact in practice on the ground in an individual arbitration. The arbitration agreement. We heard earlier an Italian case which said that the arbitration agreement itself could not be enforced because of sanctions in Italian law. Now, I have to say that that decision not only was questioned by the French court, but it's been pretty heavily criticized by a lot of academic authority. And as Gary Bourne has a big section in his book on international commercial arbitrations about that very case, where he says rude things about it, and rightly so. But nevertheless, point is, there is a court that looked at an agreement, and an arbitration agreement, and said it's unenforceable. We're not going to go and make you go to arbitration here, because the arbitration agreement itself, never mind the contract that it appears in, is unenforceable. Issues for arbitrators, receiving payment, being involved in a case, issues around their impartiality and independence, issues around travel restrictions for the parties, for the witnesses. Can they come to the state in question to take part in the arbitrable process? And is it a fair process if they can't? Reporting restrictions. What if the participants in the arbitration learn information that triggers a reporting obligation? I should say reporting obligations, not restrictions. Reporting obligations. That can raise difficult questions. And there's a point I'm going to come to in a minute in all of this. A question that I asked earlier, public policy. It's ground for setting aside an award under Article 34 of the Model Law if the award does not comply with the public policy of the place where the arbitration took place, the seat. So tribunals, who after all have a duty to render an enforceable award, need to be thinking about the public policy of the state where the arbitration is seated to ensure that they don't trigger Article 34(2)b and a set-aside issue. Now, this is my point at a practical level. All of these things may be capable of resolution, they may be capable of avoidance, there may be an answer to them, but I'm a lawyer who represents parties in arbitration. My clients do not want to have to pay me to resolve these issues. These are expensive issues. Why would my clients want to be involved in a long argument about whether a particular issue was arbitrable? Why would my clients want to have to pay the lawyers to brief the tribunal on public policy at the seat of arbitration, which will be a very expensive brief, let me tell you, in order to ensure that the award is not going to be set aside? This is the practical consequence of these things. We can have academic discussions for as long as we like about how these things impact arbitration, but that costs money. Every hour costs money. And if you can avoid it, why wouldn't you? Having said that, it's not as if you can escape these things altogether. It is not, just to be clear, a perfect solution to seek your arbitration in Malaysia. The analogy, Ben Hughes used the analogy earlier of drones being launched from one state and flying across another, which resonated for me, not least because at 7:30 this morning I was on the phone to California with the people who make the Predator drones about a piece of work we're doing at the moment. But point is that drones fly across borders and they have effect in other cases, so do sanctions. So even if you have a case seated, for example, here in Kuala Lumpur, there will be implications from sanctions for individual arbitrators. Can they act in relation to these parties? For law firms, take my firm, take Herbert Smith Freehill. My office in Singapore is a branch of my London office. Can I act for a sanctioned Russian party in a Kuala Lumpur arbitration? Because I'm a UK national, working for a branch of a London law firm, and the UK has restrictions in place. Of course, you can't escape from sanctions even in Kuala Lumpur because they can, as we've heard a lot about earlier, form part of the applicable law in the particular dispute, part of that substantive law. You have to apply that law. Even if it doesn't form part of the substantive law, or arguably doesn't, does it form part of the public policy that that tribunal has to think about? What if in response to Indonesia shooting those drug traffickers, the world, through the UN, had imposed sanctions on Indonesia? Even if that had not been translated into an applicable domestic law, does that represent some sort of a transnational policy that a tribunal has to apply? I suspect not, but there's an issue to be thinking about. I said that tribunals have a duty to render an enforceable award. So do I, as a tribunal sitting in Kuala Lumpur, have to think about where that award is likely to be enforced and whether in that state there will be sanctions issues that will affect the enforceability of that award? I ask it as a question. And of course, we get back to this whole issue again of an institution in Kuala Lumpur receiving funds from a potentially sanctioned state or a potentially sanctioned individual. Those funds have to go through the international banking system and may get trapped in that system by applicable sanctions. So the question, let me say slightly undiplomatically, inherent in the whole of this conference about whether KL is a good centre for sanctions-related arbitration, it is not a perfect centre because these issues still apply. But it may very well be that it's it is better than states which themselves have an applicable sanctions regime. I want to read you an email that I received from one of my colleagues just the other day. I'll skip to the relevant part of it, but it's very, very relevant to this. I was talking yesterday, says this person, to the general counsel of our client XYZ company. Doesn't matter which the company is, but take it from me, XYZ company is a very large Russian state-owned entity. He told me that all Russian state-owned corporations have now received a very clear instruction from the state, a reference to LCIA, Stockholm, and some other arbitration institutes in countries applying sanctions may not now appear in new contracts starting from 2015. The recommended institutions now are HKIAC and SIAC. So, there is an opportunity there, and there's also something that KLRCA may want to ponder on about the opportunity in Malaysia, which it seems is not right now front and center of people's minds. Hong Kong, if you look at their website, is very alive to this right now. The Hong Kong Secretariat is busy publishing articles, issuing blog pieces, going on tours to Russia to promote Hong Kong as the preferred center for arbitration now for Russian-related contracts. Singapore, which has been a little bit behind that game, is just waking up to it, and they are starting to think quite actively about how they should market themselves to Russian-related entities in relation to their contract disputes and their arbitrations, given this instruction, as it appears, not to be using Stockholm, London, and other Western European centres. Kuala Lumpur, I think, appears to be well aware of the subject. After all, we're here for a day to talk about it. I suspect there is more that Kuala Lumpur could do to position itself to win this work, and it's certainly worth doing so. International arbitration is good business for an economy. You look at what Singapore is doing. It's not doing it from the goodness of its heart. It's doing it because it makes a lot of money out of it. KL has the infrastructure to support international arbitration beautifully, and Faris's presentation, or Datuk Sunja's presentation, surveyed that. One point in particular which I thought was good is the judiciary here is moving beyond sort of slavish application of law to actual creative thought about how to apply arbitration law in support of arbitration. And Toby Landau gave a very good presentation in Singapore a few weeks ago on the subject of anti-arbitration courts. And essentially what he was saying was that it's all very easy to criticize courts as being anti-arbitration if they set aside awards or refuse to enforce arbitration agreements. Actually, courts that do that are supporting arbitration if they are policing arbitration properly, and it may very well be right for courts to set aside awards, and they shouldn't be shy to do that if they're thinking properly about the application of arbitration law. And I think Malaysian courts are also now moving in that direction, which is encouraging. So, I guess I say in a sort of very on-message way for this conference that there is an opportunity and we should seize it here in KL. There is a real opportunity. And maybe in the last part of this presentation, last part of this panel session, we should now try and explore how these practical issues can be mitigated here in KL and how KL can seize these opportunities. With that, in order not to keep saying further things that everybody has already said, I'll stop. Thank you.